Good evening. This is Laws 11057, Introduction to Law. It's week 3, and this week we'll be primarily talking about matters involving the sources of law in Australia, which is based on Chapter 5 of your text, which is the new lawyer. And I'm broadcasting from home tonight, so it'll look a little different. Now, just in terms of practicalities, it appears that someone hasn't muted their mic. If you could do that for me, Gordon, just down the bottom left-hand side. Thank you very much. Having said that, please ask any questions and make any comments as we progress. Last week we were talking about the difference between law and equity. It occurred to me that I hadn't been as comprehensive as I probably could, so I'm just going to briefly talk about equity, some of the maxims that are associated with equity, and some of the equitable remedies that are available to litigants seeking an equitable remedy. And you recall the distinction between law and equity: legal remedies, very hard, fast, firm, as opposed to equitable, which deals with fairness and is much more flexible in terms of outcome. Now, there are a whole lot of maxims that apply to equitable principles, and they're kind of corny in a way, but I'll run through some of them. Equity follows the common law. One who seeks equity must do equity. So again, it's all based on fairness. So don't come here if you're doing the wrong thing. Now, I remember speaking to a judge in relation to a judgment that had been made, which on its face seemed very straightforward. But now, I'm not sure who's not muted, but we'll ask if you would just mute your microphone. That might be you, Kate. That'd be you, Kate. Thank you. If you could just mute your microphone, unless you want me to do that for you.
Yes, please.
Okay. We're done. And I'll do the same for you, Annette, if you don't mind. No, I can't. I'm having trouble in muting your microphone, Annette. Oh, thank you very much. But having said that, please interrupt me if you have any questions or comments that you wish to make. The purpose of muting the microphone is simply to avoid any background noise. So we're talking about this judgment, and on its face, it seemed a very straightforward matter. A person had lodged a caveat. You'll become familiar with that when you do property law. It's essentially a document which is intended to stop the register in its tracks. So if you're an owner of real estate, or you're buying real estate, let's say, in order to protect your interest as a prospective purchaser, you can lodge a document at the titles office called a caveat. And the intention is that it stops anyone else from being able to do anything with that property pending settlement. Anyway, a caveat was lodged, and it all seemed very straightforward. But in this instance, the court said, I'm not going to give the buyer the equitable remedy of specific performance, even though they've lodged a caveat, because they weren't genuine in their dealings and there was some illegality associated with the transaction. So that's an example of where someone who goes to court seeking an equitable remedy, specific performance, is denied that because they weren't doing equity themselves. And you recall from last week, specific performance is an order of the court forcing or compelling someone to proceed with a contract. Please stop me if I'm going too fast or if I'm getting too far off track. So we're just talking about equitable principles, some of the sayings that go with it. Equity aids the vigilant. Equity does not assist a volunteer. Equity sees that as done what ought to be done. Equity delights in equality. Equity follows the law. I've mentioned that one. Where equities are equal, the law will prevail. Equity will not compel an imperfect gift, etc., etc. So if at some stage you feel interested in doing so, have a look at equitable remedies or equitable maxims, and you'll get an idea of what we try to grapple with when we're trying to pursue equitable remedies. It's not always straightforward, so that'll give you some idea of something to look at into the future. Now, tonight, the other thing is, has anyone seen any law movies? In the first week, I seem to recall asking people to look at law movies or nominate movies because I'm pretty keen on them. Can I just say this week I saw a 1957 film. It's called 12 Angry Men. It features Henry Fonda And if you haven't seen it, it's really great movie to watch. And just look at juror number 8 and just think about the way in which juror number 8 negotiates. So it's 12 Angry Men, 1957. And I don't know if you're allowed to or not, but you can get it on YouTube and it costs nothing. All right. Now, let's talk about the sources of law. Legislation overrides case law, says the new lawyer, James and Field. And I think that's right. And simply because case law is reactive. Generally, we have the legislation is passed. There's a dispute about the wording in the legislation or the interpretation of the legislation. That then goes to the courts. The courts make a decision. That then becomes binding through common law as a precedent, and future courts either are persuaded by that or bound by that decision. But ultimately, if the Parliament doesn't like what the courts have done in a particular decision, they can then simply override that common law by introducing new legislation. So in that sense, we say that legislation overrides case law. Does anyone have a comment to make? Anyone puzzled by that statement? All perfectly good sense? All right. So I'll just give an example. If it's an offence to drive without due care and attention, that's the law. The question is, how do we interpret that? And it's apparent, of course, that legislation can't deal with every possible scenario. If it did, we wouldn't have cases. It would all be straightforward. So let's assume that the law says that you can't drive without, it's an offence to drive without due care and attention. The question is then, are you guilty of an offence if an accident is caused as a result of you changing radio stations? So that's the type of thing that courts need to consider. And if the matter is determined by a high enough court, the law which is made as a result of that decision becomes part of our case law. All right, any questions there? In the commentary, James and Field talk about the way in which legislation becomes law. It requires the assent of the Crown. And I just want to speak about the Crown for a moment. Governments, which are elected, come and go, but the Crown is always there. The Crown is, if you like, where title to land vests, where natural resources are retained. And the Crown you'll often see as a concept in criminal law cases, where in the higher courts, in the District and Supreme Court, they will talk about the Crown not offering evidence, or the Crown presenting an indictment, things of that nature. So the Crown is a kind of a nebulous concept, which is meant to be something that relates to the way in which everything in Australia is owned, essentially. In other jurisdictions, in the United States, they might say the people. It's the same sort of concept. It's the thing that's always there, the constant, even though governments come and go, even though ministers come and go, even though executive officers in the public service come and go. Just a comment about delegated legislation. This is interesting. This is where Parliament makes a law which effectively provides that the ability to make further rules in relation to that law is delegated to the executive. So we talked about, there's going to be something on the separation of powers in the exam. We know that. So here's another example of where the concepts are muddled. You have the Parliament that brings in a law which says that in relation to, say, traffic matters, the department, the executive, are entitled to bring in regulations or rules or bylaws which make further provision for extra rules. There's a few reasons why you might do that. It might be to cater for changed circumstances, or to save time in Parliament, or perhaps deal with unforeseen circumstances. But you can see it's an instance where Parliament is actually delegating its ability to make law to the executive. Now, have I confused anyone there, or do you follow what I'm saying? All pretty straightforward? Good. I'm just selecting snippets from the commentary in the book. You'll see the monetary limitations for different courts and tribunals. QCAT, in its minor debts jurisdiction, has a limit of $25,000, but otherwise, the monetary jurisdiction in QCAT is unlimited. Magistrates Court is a $150,000 limit. District Court is $750,000, and Supreme Court is unlimited. I'll just briefly explain the difference between the Supreme Court having unlimited jurisdiction and QCAT as a tribunal also having unlimited jurisdiction. Some disputes must be directed to a specialised court or a specialised tribunal. So if, for example, you have a dispute in relation to a planning and environment law dispute, then it'll come as no surprise that that matter will end up in the Planning and Environment Court, which is annexed to the District Court, or perhaps the Land Court. But it's a specialised court. Likewise with QCAT, and it's probably worthwhile going on the website to QCAT to get an idea of what it does in its jurisdiction. But it has exclusive jurisdiction over a number of areas, and one of those is domestic building disputes. Now, one can imagine that the typical argument might be relatively minor in terms of the dollar amounts. You know, it might be $10,000, it might be $50,000, it might be $100,000. But occasionally on a domestic building dispute, you may have something which is quite enormous. It might be well over $150,000, which is the jurisdictional limit of the Magistrates Court. It might be well over $750,000, which is the limit for the District Court. And even though it puts it into the same monetary position as the Supreme Court, because of the nature of the dispute, it stays in QCAT. Okay, so when you see in QCAT the $25,000 limit, that's only for the very limited minor debts section of QCAT. QCAT does a lot more than that. Anyway, have a look at the website of QCAT to get a better idea of what I'm saying. No questions on the chat. Everybody's still got their microphones muted. Court process. There are two types, in essence. There's the adversarial and the inquisitorial. Adversarial is what we're familiar with in Queensland, in Australia, where we have the two camps opposing each other, football style or boxing style, where one is trying to beat the other, working as adversaries, but still having an override duty to the court to act ethically and not to mislead. But it's a contest between the two. The court is there to determine the matter based on the relevant evidence and the admissible evidence which is presented to it. Contrast that to the inquisitorial style, which is used overseas in the European jurisdictions. We often see the inquisitorial style, and in that the judge will, or the tribunal member, will try to, will actually get involved in asking questions and getting to the bottom of the matter. So that's why we call it inquisitorial. Now we use, I'm sorry, being a member of QCAT, you'll forgive me for often referring to it, but we use that style of inquisitorial court process in QCAT because we're not bound by the strict rules of evidence. So we can receive hearsay evidence, we can ask questions, we can sort of get involved in it, roll the sleeves up and make inquiries to get to the bottom of the matter in that jurisdiction, whereas that's not possible for magistrates and judges. So I hope everyone has a basic idea of the difference between adversarial and inquisitorial. No questions on the chat? No comments? I'm doing my best to divert the microphone away from me, but I'm not doing a very good job. All right, addressing the judiciary. For those of you that practice in law already, you might have some idea of this, but if you don't, it's something that I think you need to know. So if you're in court, in the Magistrates Court or the District Court, the Supreme Court, the High Court, pretty much all the courts, what we now say is Your Honour. It used to be that in the magistrate's court you would say your worship, but that went out 10 years ago. So now in the magistrate's court you address the magistrate in court as your honour. So it's very common, it's very consistent between all the courts. What if you meet with a district court judge in a social context? You're at a law function, it's your first law function, and someone says, look, I'd like you to meet Judge XYZ. How do you address the judge in a social context? I suppose you could say Your Honour. There's nothing really wrong with that, but anybody have any guess on how you might address a district court judge in a social context? I'm going to have a sip of tea. No, Tony, that's not right. No, Jason, that's not right either. Getting closer, Kate. All right, here it is. No, close, Tony, but not quite. District court judge. Judge. So for a district court judge in a social context, he or she, it's perfectly proper to say judge. It's respectful to do that. There might be a few judges that will invite you to call him or her by first name, but of course you wait for that invitation. You don't assume it. In a social context, you can also call a district court judge, or a federal court judge, or a family court judge, or a federal circuit court judge. Judge is fine in all that instances as well. But here's the thing. When we're talking about a judgment of a district court judge, we're referring more formally to a district court judge, the formal reference will be Judge Brown. When we're talking about a Supreme Court judge, the reference is Justice Brown, not Judge Brown. So that's in the more formal setting. In QCAT, it's member is the official term. Magistrates in court is Your Honour, socially Mr. or Mrs. All right. Let's talk about trial procedure, civil and criminal. I'm just going to talk about criminal trial procedure a little bit. Firstly, you all know, I hope, that if the police wish to ask you questions, then you don't have to answer those questions, except you would give your name, your address, your date of birth. Beyond that, you have a right to silence and you don't have to answer questions. So if in your first week as an article clerk, you receive a telephone call from a worried client with the police in the house exercising or executing a search warrant, generally speaking, you would advise that client to be aware of their right to silence and to advise the police officer concerned that you don't wish to make any statement. Just on that, in that regard, and I had it today, police were at a home, and what I normally do is speak to the officer, ask if the client has made any statement already. If so, were there warnings administered to the client? Indicate that I'd like to speak to the client, that I'll probably advise them to, that I will advise them most likely to exercise their right to silence, and then speak to the, and then ask the officer about whether they're going to arrest the person or not, and if so, whether there's any contest in relation to bail. I'll then speak to the client, make sure that they're aware of their right. It's their decision, but I'll encourage them not to make a statement in 99 out of 100 times. That's the safe advice. So if you're stuck and you're caught in a situation where you've got to give advice in a criminal law matter on the spot, just simply say, don't make a statement. All right, any questions about that? Are there any police officers doing the course who totally disagree with that? Okay. Now, after arrest, the person who is arrested or charged, rather, will either be given a notice to appear in court, which is a little tiny piece of paper with a date to appear in court, or may be processed through the watch house typically and required to sign an undertaking as to bail, or will be kept in custody, in which case a bail application will need to be made in front of the magistrate, unless it's something like murder, where the bail application would need to be made in front of a Supreme Court judge. Now, there's a few questions on the chat line. No, they're just nothing there. Any questions, comments about what I'm saying? All right, well, I'll keep going. So let's assume now that someone is appearing in court. The first question is to determine what is the charge and then determine which court deals with the matter. So if, again, I'll try and, through this course, I'll put you in a situation that you're in your first week in a law firm and you want to make sure you don't make a silly mistake or a basic mistake. So you're standing in front of the magistrate. Your client has been charged with grievous bodily harm. The client says, look, I'm guilty, mate, just I want to get out of here. What you don't want to do is stand up in front of the magistrate and say, in relation to the matter of grievous bodily harm, my client enters a plea of guilty to deal with it now. Magistrate will say, I can't deal with grievous bodily harm. I've got no jurisdiction to deal with that. That's a matter that has to go to the district court. So you don't want to make that kind of mistake in front of a packed courtroom, and it kind of gives the impression to the client that you don't know what you're doing. So one thing that you need to do is get hold of a jurisdictional guide. I'll make a note. There's plenty of them floating around. They're copyright, but they were generally made available. And I think the people who took the time to do up these jurisdictional guides would be more than happy to see them disseminated, because that was the purpose of doing so. So I'll give you that guide, and it'll give you a quick idea as to whether a matter is dealt with in the magistrate's court, the district court, and so on. All right, now if the matter is indictable, it means that it is capable of being dealt with on indictment. So if it's indictable, it can be dealt with in indictment. An indictment in the criminal law scheme of things is a document which is presented to a higher court judge, which essentially kickstarts the prosecution in that higher court. So that's what an indictment is. It's a one-page document typically, and it says something like, on such and such a date, at such and such a time, in such and such address, your client did commit grievous bodily harm, etc. So that's presented to the judge, and the client is arraigned, which is guilty or not guilty. Anyway, that's what an indictment is, but it's not possible to present an indictment on every offence, only on indictable offences. So there's a difference between summary offences, meaning at the lower end, or indictable offences, meaning at the higher end. And some of the indictable matters can actually be determined summarily, meaning in the lower courts. So even though it's indictable, that doesn't mean that it has to be dealt with an indictment. It can be dealt with summarily in front of a magistrate in some circumstances. Now, you're going to love what I'm about to say. In 2010, the Moynihan provisions changed everything and effectively meant that probably most indictable offences now must be dealt with summarily. So even though they're capable of being the subject of an indictment, the law says, no, it's a break and enter. The amount is less than $30,000, essentially to save funding, in my humble opinion. The matter now must be dealt with in the magistrate's court and not in the district court, as was previously the case, or at least as was the case at the election of the defendant. So any questions about this? And I hope I'm not going too quickly. It's something that I want you to read about more often. But again, just think in terms of you being a first-year law student. You're in your first criminal law mention. What do you do? I should mention one of my staff members last year was having his first mention, wanted me to go through some of these basics. So I recall I did a Zoom session on the spot. There's been a few hits on that. So, because I did upload it, and I'll upload it to the course. So you'll have more time to go through this later. All right, so when you're standing in front of the client, in front of the magistrate, you know you've got to call him or her Your Honour. You know that you need to be aware of which court this matter is to be dealt with, whether it's in the magistrate's court or the district court or the Supreme Court. and then there's a procedure to be followed. If the matter does go to the District Court or the Supreme Court, it has to go through, well, generally, it has to go through a filtering process. That filtering process is called a committal, and the committal is where the magistrate determines whether there's sufficient evidence to warrant this matter going to the District or Supreme Court. In other words, is there enough evidence to suggest that a jury could possibly find this person guilty? So on a murder trial, the matter will go through a committal first, and if the magistrate is convinced that no jury could possibly find this person guilty of murder, then the magistrate will toss it out, will dismiss the charge. Yes, prima facie, exactly, Robin, thank you. Prima facie case, that's the Latin term for it. So if it's determined that there's a prima facie case, then the matter will proceed to the next level, to the District Court, where ultimately one would expect an indictment to be presented. So the committal can take a number of different forms. Typically these days, we have lost as a profession our ability to cross-examine witnesses at the committal stage, which is a real shame from a personal perspective, because that was very rewarding work to do. So most committals now are either done through the registry administratively, or they're done in front of a magistrate, but in a perfunctory form, which we call a hand-up committal, where essentially someone like me will stand up and say, I've received the brief of evidence, I've considered the material, I've taken instructions from my client to concede that there is a prima facie case, that there is sufficient evidence to warrant this matter being committed to the District Court for trial without consideration of material by you, Your Honour. And I undertake to provide my client with advice in relation to alibi and availability of legal aid. So that's kind of a very shorthand version of what a hand-up committal is. Now, of course, if it's a summary matter, it'll be dealt with in the magistrate's court, either on a plea of guilty, or the magistrate will eventually determine guilt or innocence. But if it's indictable, subject to proceeding to the High Court, we go through the committal, and once it gets to the District Court or the Supreme Court, it's then mentioned a couple of times, typically at a call-over. All right, so you're in your first week, and the partner who deals with criminal law matters in your firm is double booked, very often the case, and says, I've got a summary hearing or a summary bail application. I can't make it to the District Court call over. You'll have to go. I want you to set the matter down for trial. So here you are, you're off to a call over. Has anyone heard of a call over before? No? Now, Tony, did you want to ask a question? No? All right, well, I'll continue. So a call over is where the list of matters which are before the District Court judge are mentioned, typically one after the other, to determine what's happening. So it's all very exciting when you first go to a call over, because you're standing in front of a District Court judge or a Supreme Court judge, and it can be very exciting and it can be very nerve-wracking, but at the same time it can be a little bit administrative in nature as well. Tony, the reason you can't cross-examine at committal, in my humble opinion, it is primarily based on economic reasons. Now, I am sure that politicians and others will vehemently disagree with me, and they will suggest other good reasons for not being able to cross-examine at committal, but that's my view. And you notice I'm being very careful. If I say anything contentious, I make sure that you know that is simply my opinion, not the opinion of the university or anything else, and I'm entitled, as we all are, to your opinion. Okay, I hope that answers it, Tony. So we get through the call over, and eventually the matter is set down for a trial or sentence. It might be preceded by a pre-trial argument or a thing called a pre-record. In the District Court or the Supreme Court, you'll hear matters being set down for trial or sentence. What that means is essentially not guilty or guilty. So you don't, it's just funny, in law, you get these different ways of talking. And in the District Court, That's what we normally say. The matter's going to be set down for sentence, which means it'll be a plea of guilty. Okay, I know I've talked a lot and I've talked quickly. I hope you've been able to take it in and I haven't gone too fast, but I did want to introduce you to some criminal law procedures, just in case you get caught having to appear. Now, civil trial procedure, entirely different, of course. This is usually commenced by paperwork. That paperwork typically is a claim accompanied by a statement of claim, or it might be a summons or an application, but it's some sort of paperwork which is filed. Typically that then is served, or a copy is served on the other side. If the other side don't turn up, or don't file a defence rather, within 28 days, you're at liberty to apply for a judgment by default, or alternatively, the defence is filed. It might be accompanied with a counterclaim, and the matter then goes through pre-trial disclosure, which is where there's an exchange of documents. It might well go through some form of alternative dispute resolution, but if it doesn't resolve at ADR, it will then be the subject of a certificate of readiness for trial, and the matter will be set down for hearing. Now, unlike the criminal jurisdiction where it starts in the magistrate's court and either stays there or filters through to the higher courts, in the civil law regime, you commence your proceedings and finalise your proceedings in the one jurisdiction typically. There are some exceptions to that, but if you've got a family law dispute, then you decide to either go to the family law court or to go to the federal circuit court. Now, some of you might say, what's the federal circuit court? It is what we used to call, until very recently, the federal magistrates court, but it's been renamed, rebadged, and the federal magistrates are now federal judges. All right, any questions about any of that? Do you send out a letter of demand first, try to settle before litigation? Yes, or you can go straight to ADR. You don't have to issue proceedings. You can select some form of alternative dispute resolution. And I'm doing ADR this term as well as Intro to Law, so you'll probably hear me talking a bit about that as we go through. Now, surely someone must have a question after all of that. Nothing on the chat line? Nobody wants to make a comment, ask a question? Yes, there is lots to take in, Kate. All right. I haven't got much more that I want to say today. I'm going to leave you to read for yourself the way in which laws are introduced and made into legislation. I think you can read for yourself the structure of Parliament. I think we all know that in Queensland we don't have an upper house as we do in other state jurisdictions and the federal jurisdiction. I think you all know about double dissolutions. You don't need for me to tell you about Gough Whitlam's dismissal. Consolidated acts, well, that's pretty straightforward. That's just where bits and pieces of legislation have been consolidated into the one act. I will mention something about codification. You'll sometimes hear of an act being referred to as a code, and or sometimes as a law. Perhaps the criminal code you'll come across. The intention of a code is, when it's introduced, it's meant to be all-embracing, so that whatever you need to know about the legislation to do with criminal law is contained in the code. Well, that works for a while, but then it breaks down. So even though we do have a criminal code, we now have many other laws, pieces of legislation that deal with criminal law matters, even though they're not contained in the code. So, for example, Drugs Misuse Act, Summary Offences Act, Police Powers and Responsibilities Act, etc. So a code is what it's meant to be, but that's not necessarily what it is in practice. Sometimes things are called a law. Probably the most prominent one that comes to mind is the consumer law, and that's meant to be all-embracing. So, and that's the actual name of it, the consumer law. That's well worth having a look at. So tonight, for homework, apart from all the work you've got to do and the assignment that's got to be in on Monday at 5 o'clock, and thanks very much for those of you who have already submitted it, I would like you to read something about appearing in magistrate's court for the first time, I'd like you to read something about the process of civil procedure, and I'd like you to have a look at the criminal code and the consumer law. Now, has anyone got a preference for looking at these things through the authorised services or through Ostly, which is not authorised? I've got to confess, I go to Ostly. I just like it. Does anyone know does anyone not know what I'm talking about? No questions? AUSTLII. Google it, it's fabulous. You'll see where all the legislation is contained, and it's free, Tony, absolutely. And have a look at the most brilliant function, which is Note Up. Note Up, you see it on the top right-hand side. So do this as an exercise, try and find section 754 of the Police Powers and Responsibilities Act, and look at that section, and then press the Note Up button. Now, having said that, there might be nothing in that one. I'll look it up as we go. Sorry, I'm not very good at sharing screens. I used to all the time, but it used to drop out on me, so I stopped doing it. 754. Anyway, have a look at that and just poke around, or go to the criminal code and look at, say, section 24, push Note Up, and you'll see lots and lots of cases that are relevant to the matter. Has anyone tried that yet? Now, Jason, you want me to repeat those 4 items? I'm not sure which 4 items they are, sorry. Was that the homework? Homework, we want you to know something about criminal law first appearances. I'll provide you with my Zoom recording. I'd like you to have a look at Ostly and look at some legislation just to get a feel for it. In there you'll find the criminal code and you'll find the consumer law. And then I want you to look at the Note Up function. And as we speak, I'm looking at the Police Powers and Responsibilities Act. And I'm looking at section 754. Which is the offence for a driver of a motor vehicle to fail to stop a motor vehicle. Relatively new legislation introduced, where you might be interested to see that the minimum penalty if a driver fails to stop motor vehicle when called upon by police to do so is now 100 penalty units, $5,500, or 100 days imprisonment served wholly in a correctional centre, or 50 penalty units or 50 days imprisonment served wholly in a correctional centre. And if we look at the Note Up function, yes, there's one case, there's 2 cases there. So Police against Stewart and Commissioner of Police Services against Magistrate Spencer. And I think I may have mentioned before, when you're citing cases, don't say versus or don't say v, or you can say, don't say versus. So I normally say Police and Stewart instead of Police v Stewart, but you can say v, or but not versus. All right. So again, it's been an awful lot of items that we've covered, Jason. I hope that gives you some idea of some homework to do. Are there any questions before we call the meeting to an end? Any comments? Okay. All right. Well, I'll end the meeting now. I'll stop. Was that a question coming through?
Yep. Sorry, not so much in regards to the Zoom session, more so in regards to our exam timetable. Have you heard or seen anything in regards to that yet?
Sorry, I forgot about the mute button. Sorry, Jason, I have no say in the exam timetable or timetabling, and we only receive information when you do about when the exams are to take place. Sorry. Now, was there any other questions? Nothing else, Jason? Tony, you weren't asking a question?
Just about that turn it in thing, I put my thing in the other day and it came up at 54%. And when I had a look at it, you know, it was all the footnotes and that were highlighted. And
Sorry. Yeah, with turn it in, I do look at that, of course, and if it's simply reflecting the fact that you have referenced some material, then that's fine. That's what we want you to do. So just because it might show 54%, that doesn't mean at all that you're doing anything wrong.
I
but if
realised
it shows,
that
yeah,
because I had a look at it and everything I highlighted and reference was highlighted.
that's fine. Yeah. So obviously what it's looking to do is identify if you have plagiarized in circumstances, which means, of course, that you haven't referenced. But if you've referenced, it's very hard to be guilty of plagiarism. Quite the opposite. You're saying, this is where I got it from. Thanks, Tony, but that's a good observation. Any other questions about assignment work or anything else to do with the course? Okay. Well, I might stop recording and thank you very much.